Let's bring Richard Ekins into this, Head of Judicial Power Projects at the centre-right think tank Policy Exchange, Professor of Law at Oxford University. What is your reaction now to the ruling 24 hours on?
Well, I think the court made a bad mistake yesterday. They should have upheld the High Court judgment 2 weeks ago and given judgment in the government's favour. I think the court has decided a political question which the law requires to be left to the political process.
And you have this view, which is obviously diametrically opposed to someone else with lots of knowledge of the legal profession. How can that be if people are listening? How can you reconcile those two views to people?
Well, lawyers often disagree, and we've had senior judges disagree here. There were 3 extremely senior judges in the High Court who were overruled yesterday. And I would say that what happened yesterday, and it's worth reading the judgment and seeing how weak the reasoning is. I think what the Supreme Court did was change the law. It made up a new law yesterday. It decided that there was a political crisis and that it didn't think constitutional practice was being properly followed. And so it's extended legal controls over a political question that was not for it to control.
But the political question was whether Parliament itself should be essentially sitting so that it could monitor itself and do what it's meant to do. And what do you do if you think, as those people did who brought the case, that it had been prorogued wrongly? Where else can you go if you are in that view?
Well, the first port of call is the House of Commons.
Which could have withdrawn. There if it's not sitting.
Well, you could have, though. There was a gap between the prorogation, the announcement of the prorogation and it being carried out, and the House of Commons could have withdrawn confidence then. They could have been so unhappy with the government that they were willing to bring forward an early election and to find a new government. So we have this odd situation.
You know that there are some issues with that around no-deal Brexit.
That's the reason, though, you could have had a very simple Act of Parliament that made provision for an election on a fixed date well in advance of a no-deal exit.
So are you saying the tacticians in the House of Commons let their own game fall?
Well, I think it's the House of Commons' responsibility to hold the government to account, including for the use of the power to prorogue. And that's been the position for centuries.
There are quite a few lawyers, former lawyers, in the House of Commons. If you know this and they know this, why didn't they do it?
Well, I think some people brought the case and some people are in the House of Commons, and there's some overlap between some of them. But there can be an advantage, of course, in trying to secure a sort of political victory in the courts. And I think that's what we saw here, actually. And it's a shame. I think the courts have been open to it.
Hang on. So you're saying that some people knew that they could do what you've just described, but chose not to do it because of these court cases, and these are people who are not even to do with these court cases?
Well, I'm sure the House of Commons knew it could withdraw confidence, and I'm sure they knew that they could support an early election. And they decided
it's just,
not to.
Those unprecedented, again, to use the word, and I'm sorry, but it was, but those scenes where they were holding on to the speaker and it was kind of going, the House was sitting till 1 o'clock in the morning, 2 o'clock in the morning, only a few days ago. I'm just wondering why no one put their hand up and did what you're saying.
Well, that's a question for them. But it was widely discussed, the option of moving a vote of no confidence. And it's a pretty strange position to be in with a government that clearly doesn't enjoy the confidence of the Commons in one way, and yet confidence hasn't been withdrawn. That is a constitutional problem.
Yes. So what you're saying about it yesterday is it shouldn't have gone to the courts in the first place, but the very fact that it did, you don't think the courts should have ruled how they did?
Well, I mean, people can bring an action, of course. The question is what the courts do in response. I think the High Court and the judge at first instance in Scotland did the right thing in concluding that the law makes this a question that's not for judges to decide. That's been the position for centuries. It's a position in other common law countries. It's a position, too, reinforced by a pretty important statute from 300 years ago. It says you don't question proceedings of Parliament.
But then how did Baroness Hale do it? How did she make the judgment? Because it's been praised by others in the legal world for its clarity and the fact that it's been very surprising for people that it's unanimous.
Well, it is very surprising, and I was certainly surprised it was unanimous. I think the judgment is quite weak in its reasoning. It purports to not take over to exercise judicial control over whether you exercise the power to prorogue, but in substance that's what it does. It says you have to have a reasonable justification, reasonable in the eyes of the court, for proroguing. And that has not been the position in past times. And it also relies on some important principles, but principles that don't support this judicial intervention. Parliamentary sovereignty, which is not breached remotely by prorogation, and parliamentary accountability, which is not for the courts to enforce. It's important, but not every important question is a question for courts to decide.
Professor Richard Ekins, thank you very much for your time this morning. Head of the Judicial Power Project at the centre-right think tank Policy Exchange and Professor of Law at Oxford University.